I'm Sara Meyer, a Senior Legal Advisor at EEF. We're a UK-wide provider of HR and legal advice and consultancy. One of the main reasons that HR advisors call us is to discuss discipline issues. They understand that handling a situation in the right way can help avoid the risk of an employment tribunal, improve employee relations, and avoid distractions that impact on productivity. So disciplinary action is not supposed to punish the employee, it's actually intended to improve their conduct or their performance. And it is really important for the same type of misconduct to be treated consistently. Inconsistency of treatment can mean that employees raise grievances, and if somebody is dismissed and brings an unfair dismissal claim, inconsistent treatment can prompt an employment tribunal to find in the employee's favour, even if the employer might have a strong defence otherwise. It's important to investigate disciplinary issues promptly. Don't rush, but start as soon as possible. And also keep the employee informed of the progress of the investigation, especially if it's taking longer than you first thought it would. And this is particularly important if an employee is suspended, waiting on the outcome of whether they're going to face a disciplinary. Investigations should be thorough. It's important that the manager looks for evidence not just against the employee, but also some things that might support their defence. And witnesses will need to be interviewed and have their statements taken. Once the manager has completed their investigations, they'll have to weigh up all of the evidence and decide whether it's necessary to proceed to a formal disciplinary hearing. Whatever the decision, they have to inform the employee promptly so that they're not left hanging. So the first thing to do when preparing for a disciplinary hearing is to decide who should actually handle the decision. This has to be someone who's sufficiently senior to have the authority to make the decision, and where possible it should not be the same person who conducted the investigation, so that you avoid any suggestion that the decision was predetermined. The employee has to be given reasonable notice of a disciplinary hearing. They should be invited in writing, and the letter should set out the allegations and summarise the evidence so they can prepare their defence, and should tell them that they're entitled to bring a colleague or a trade union representative with them to the hearing. So a key means of support for managers handling disciplinaries is training, because disciplinary issues can be very daunting for less experienced HR managers. The training might include advice on how to conduct a disciplinary investigation or guidance on running a hearing. So, for example, from the opening formalities through allowing the employee to present their case to concluding and adjourning to take a disciplinary decision. For more information on how we support HR through tools, policies and advice, visit eef.org.uk/discipline.